Milady, if my learned friend Mr. Greenbaum could just briefly deal with the question that your Ladyship raised just before the short adjournment.
Thank you.
I'm the only one of the four of us who was at the hearing in April 2011.
I thought you must have been getting to these cases for really quite some time.
My hair was a different colour in those days. Mr. Quiney has been able to speak to his instructing solicitor, who sits behind him, who was also there, to confirm the accuracy of what I'm going to say to you. There was a dispute between the claimant's team and the two teams representing different defendants, insurers, who were at that hearing, as to the scope of the medical evidence that should be obtained in these cases. The services agreement contemplated only one form of medical examination, which is that which is referred to at paragraph 9.5 of the Statement of Facts, which is on page 46. I don't ask you not to turn it up. It was called the MAP 2, and it was purely for the purpose of seeing whether there was any comorbid condition. So it's solely a comorbidity-directed examination, and it was the submission on behalf of the claimants that that was all that was going to have been done in these cases, and that was all that should be done in the professional negligence litigation consequent upon it. The defendants didn't agree. They said that there should be medical evidence dealing with the extent of disability and indeed diagnosis. And their view prevailed with the judge. There was a disagreement between the two defendants' teams as to whether there should be one jointly instructed expert or whether each party should have an expert, and the judge decided that it should be one jointly instructed expert dealing with the matters which came to be set out in the order. And that is the reason why the order came to be in the form that it was.
Thank you. That's very helpful. Thank you. And that's what Mr. Tennant was instructed to do.
Milady, my lords, if I may, I will then turn to causation and take this court to various parts of Judge Safman's judgment where he deals with it. And our submission is that what it reveals is an incremental shifting formulation of the straightforward issue of causation. It is not acknowledged by the judge that that is what is happening, nor is the shift justified. And the first of those formulations is that which Mr. Pools took the court to at paragraph 88, page 170 of volume 1 of the core bundle. And this is the correct formulation, and Mr. Pools accepts that it is a correct formulation. The onus is on the claimant to establish causation on the balance of probabilities. The claimant therefore must establish on balance that he would have acted differently if properly advised, and the lack of opportunity to do so has caused him loss. In other words, the claimant must establish that the breach of duty actually caused him loss. And we accept that that is a proper formulation of the test. Unfortunately, however, the judge did not directly answer that simple question, and nor did he make a factual finding that Mr. Perry's unambiguous evidence that he would have made a services claim had he been advised thereof was untrue. And the unambiguous evidence, my lady, my lords, is in core bundle 2, behind tab 17, the first witness statement of Mr. Perry, and the relevant section starts at page 530, and it goes through to page 533. I don't propose to read through it now, but what it sets out is the understanding that Mr. Perry had about the services claim as a result of what he had been told by solicitors now representing him. And then at paragraph 45 on page 533, he says, I would have been happy to receive some of the offer as an interim payment, that was his general damages offer, and continue with a services claim. If they, that is Raleys, had advised me about services, I would have definitely made a claim. I could easily have got evidence together in support of the claim from my sons and my wife. So that is an emphatic statement that he would have acted differently. The next formulation of the causation test is to be found at paragraph 114 of Judge Safman's judgment, and it represents the first incremental step. That is at page 175 of the core bundle. I therefore now turn to the issue of whether the breach caused the claimant to settle his claim at an undervalue because, on balance, it properly advised, and if properly advised, and on the assumption that he was acting honestly, he would have acted differently and made a successful claim for a services award. So what is inserted there is the assumption that he is acting honestly. It is at this stage an assumption, so presumably somebody who wishes to contradict it would need to do so. A few paragraphs on, in paragraph 118 on the same page.
Forgive me, what do you say about that?
Well,
formulation?
The assumption, my lord, is neutral in a sense, in the same way that a trial judge will usually assume that the witnesses who are giving evidence are telling the truth until the contrary is demonstrated. They don't have to come to court, particularly if they're one of the parties, and discharge an onus that they are honestly making the claim. The fact that they are making the claim gives rise to that assumption. But it doesn't bring about some onus, evidential or otherwise, on the person making the claim.
Thank you.
And he
Do you also query the word successful?
Indeed, my lord, that is the other incremental step that has been taken. And that is something which the judge is now saying has to be shown on the balance of probabilities. Then in paragraph 118, at the bottom of page 175, top of page 176, it's the top of page 176 really, Mr. Quiney emphasized, and as indeed Mr. Greenbourne agreed, well, my lady, my lords, you have in our written case that that is not an agreement that was made. The claimant must establish that he would have advanced these claims and that as a fact he could not carry out the tasks unassisted and had done so before the onset of the VWF. So again, that is a way of saying that he could make a successful claim on the balance of probabilities. And the question is,
after this lengthy inquiry into what was agreed and what wasn't agreed, it is clear that Mr. Greenbourne agreed that the claims had to be honest.
yes,
And you could read the judge's reference to his having agreed that as a fact he could not carry out the tasks unassisted and had done so before as a longhand way of saying it's agreed that the claim had to be honest.
well, my lord, it's the final section of that paragraph where in the last 3 lines he says, the question is whether the claimant has established that in reality any loss of function manifested itself in an inability to carry out the tasks. So that again is requiring that he should prove on the balance of probabilities that he could not carry out those tasks and that the underlying claim would have succeeded.
But if he could carry out those tasks and made a claim, could it be an honest claim?
It would be, my lord, yes.
What if he could carry out those tasks unaided?
Yes, my lord. But I'm so sorry, my lord, if he could make the tasks.
Yes, putting it the opposite way around to
yes.
The judge, if he did not have an ability to carry out those tasks in reality at the relevant time, that is, the time when he decides hypothetically to make a claim, could he make an honest claim?
If he was able to carry out the tasks without any assistance, then it would not have been an honest claim.
So why is that last way in which the judge puts it at the last 3 lines of that paragraph saying any more than, I must be satisfied that he would have made an honest claim?
Well, my lord, because it is requiring him to show on the balance of probabilities the factual matrix. And that is something which the judge later on in his judgment says the claimant has not discharged the onus of satisfying him, that he, the claimant, satisfied the factual matrix.
But the advice to him, good, competent advice would be, if you satisfy the following factual matrix, you can make a claim.
Yes, my lord.
So he would say to himself, do I satisfy this factual matrix? And he'd be best placed to know he either would or wouldn't.
It is more complicated in this and many of the cases for the reason of comorbidity. And there was comorbidity in this case, and as my Lord Hodge asked my learned friend in the course of his submissions, the fact that the younger son, Scott, for instance, could not say whether the father's need for assistance was as a result of the back or the hands. All he knew was that he needed assistance. Indicated that assistance was being given in a way, and I say the same goes to honesty. Somebody who now requires assistance may not realize the extent to which that is referable to his hand problems as opposed to his back, or a combination of the two where there's comorbidity as there was in this case. But the judge then went on in paragraph 118, I've taken you to that, but he says, in reality, any loss of function manifested itself in an inability to carry out the tasks. So he is requiring, on the balance of probability, that those facts are proven.
So he's not looking to his subjective understanding at all. He is looking to the establishment of the case.
Of the objective facts, yes.
Objective facts, yes.
And in paragraph 119, it then shifts into a question of credibility, because as Mr. Quiney put it, the judge records, has the claimant succeeded in persuading the court that he actually suffered sufficient disability that he could honestly say, I cannot carry out these services? Only if the claimant satisfies me as to that do I need to consider whether his inability to do so is referable to the VWF and the back problem, or simply the back problem. So the assumption of honesty has now become a requirement that honesty shall be proven, and also that the underlying facts shall be proven on the balance of probabilities. No authority is cited for this development of the test for causation. And the causation issue here is, if properly advised, would this claimant have acted differently by making a claim? our submission is that in developing that simple question and that simple test for causation in the way that he did, His Honour Judge Safman actually disregarded long-standing precedent and long-accepted principle and policy when it comes to assessing claims of professional negligence made against solicitors who have either lost a claim for their client or failed to advise him or her of a head of claim which was available. Can I start with the most important case, and that is Kitchen and Royal Air Force, and that is behind tab 16 of the authorities bundle.
Be able to give us the electronic page to which you're going to refer?
I will, my lord. It's 1,212 through to 1,229. My lady, my lords, this was the landmark decision reported in 1958, which recognized that Chaplin and Hicks applies to claims for negligent omission by solicitors, and in this case the omission was not failing to prosecute the case so that it was struck out, but it was failure to issue a writ within the limitation period. The claim arose out of the death of the claimant's husband, who was electrocuted in their kitchen when he was making his wife a cup of tea. How he came to be electrocuted, as you will see when I take you to the passage, was shrouded in mystery. The solicitors were instructed on behalf of the claimant, but they failed, contrary to counsel's advice, to obtain an expert report on the cause of the electrocution, and consequently no claim was brought within the limitation period. The solicitors were held to have been negligent, and their appeal was heard by the Court of Appeal, headed by the then Master of the Rolls, Lord Evershed. The important passage to start at is at page 1223 in the judgment of Lord Evershed. The second half, the lower half of the page, about 6 lines into that paragraph, Mr. O'Connor, who was representing the appellant solicitors, Mr. O'Connor's point is that we have now to consider the question of liability as between the plaintiff and the electricity company, or their successors, as though it were a distinct proceeding within the present action. And Mr. O'Connor says that if we find on balance against the plaintiff, that is to say, that she fails in her claim against the electricity board, considered as if they were a separate and existing, if there were a separate and existing proceeding, then it follows that her damage is no more than nominal. That is the right approach. It must follow that in any case such as the present, the result expressed in terms of money is always all for the plaintiff or nothing. I cannot, for my part, accept that that is the right formulation of the problem. And then he goes on to separate the 3 types of case. In this kind of action, it is plain that an action could, if it is plain that an action could have been brought, and if it had been brought that it must have succeeded, of course the answer is easy. Damaged claim plaintiff then would recover the full amount of the damages. On the other hand, if it be made clear that the plaintiff never had a cause of action, that there was no case which the plaintiff could reasonably ever have formulated, then it is equally plain that the answer is that she can get nothing save nominal damages for the solicitor's negligence. And then he refers to a concession made by claimant's Respondents' Counsel that if it simply said, I have nothing but a nuisance value claim, that will not found a claim against the solicitors. But he says the present case falls into neither one nor the other category, and there may be many cases where it would be impossible to try the action within the action. The question, and this is in the third paragraph, 3 lines in, the question is, has the plaintiff lost some right of value, some chosen action of reality and substance? In such a case, it may be that its value is not easy to determine, but it is the duty of the court to determine that value as best it can. Moreover, he, having seen, 2 lines down, moreover, he, having seen the plaintiff in the witness box, found expressly that she was truthful and a candid witness, and that was the trial judge, and he awarded her £2,000. So, quite emphatically, it was determined that there should not be a trial of the underlying claim which was lost.
Was this a causation case?
My Lord, it was in the sense that limitation had been missed. I don't understand from the report that an issue was taken as to whether the claimant would not have brought in action.
No, quite.
It may simply have been assumed that she would have done so.
Thank you.
But the point I did make was that this wasn't a case that had been struck out for want of prosecution and evidence had been lost or rendered less reliable as a result of the delays in bringing the solicitor's negligence action to trial. Now, an important point to recognize in this case is that if Judge Safman's requirement that the claimant must prove the underlying facts on the balance of probabilities were correct, Kitchen would have failed, because what emerges from the judgments of Lord Evershed and Lord Justice Parker is that they could not ascertain in any way what had caused the electrocution. And we see that at page 1225, at the top of the page, where Lord Evershed says, the whole case is fraught with mystery, and you are almost at a loss to conceive of how such a state of things could ever have arisen. That is what it is that brought about the death of the husband. And to the same effect, in the judgment of Lord Justice Parker, at the bottom of the page, about 10 lines from the bottom, he says, the matter remains a mystery, and were it necessary for this court to decide whether the plaintiff would have succeeded, I, for my part, would have found great difficulty in coming to that conclusion. But as I understand it, that is not our task. If the plaintiff can satisfy the court that she would have had some prospect of success, then it would be for the court to evaluate those prospects, taking into consideration the difficulties that remain to be surmounted. Now, that is the test which was established in the Kitchen case and has been applied uniformly since in the Court of Appeal, first instance, and indeed there is a reference to the case in our written case by the Privy Council in the case of Phillips and Co. and Whatley, and that is at tab 19. The reference is given in our written case, but what Lord Mann said in that case was that this approach to professional negligence actions was the conventional approach, and that is to be found at page 1264, I believe.
No, that's the headnote.
Yes. If my lady and my lords will bear with me, I will find it. My learned friend, Mr. Greenbaum, is going to try to find the passage. This case as well was not one where the underlying claim was struck out for want of prosecution, but rather the limitation period was missed.
So the case was about the quantification, wasn't it?
Yes, indeed, my lady. But our submission is that if it is not appropriate to carry out a trial within a trial in respect of the quantification, because of the difficulties that arise in doing that, it is equally inappropriate then to carry out a trial within a trial on the much more straightforward issue of causation, which really is concerned with the disappointed client's intentions at the time that he or she was let down. There are good policy reasons why, from Kitchen onwards, it has been recognized that it is inappropriate to carry out a trial within a trial. And it surely can't be right that it is not done for quantification and that an assessment of the loss is carried out, if the court should do so when it comes to causation. If they can do so for causation, then equally the winning claimant should get 100% if he or she succeeds on causation, or nothing.
There are two separate questions. Would the claim have been brought? What would the outcome have been? And in lots of cases, it's impossible to answer the second of those questions for the sorts of reasons that in the Kitchen case and in Hanif, and lots of cases where that's impossible. So not surprisingly, what's being assessed is the value of the chance that the person has lost. But that's not the same with the causation issue. There, as you have just said, it's a straightforward issue. Would this person have brought this claim?
Yes, but milady, the problem is once that straightforward, simple question is converted into something else, and can this person demonstrate on the balance of probabilities that he or she would have won in the underlying claim?
Yes, I'm not. I'm not denying that distinction. Of course, I'm not.
Yes. And
what
that's,
this judge was doing is a different question. But.
Yes, and that's why in our submission, in requiring that that were established by this particular claimant, the judge has answered the wrong question. He asked the right question originally, he's added to the question, and he's ultimately answered the wrong question. And he did, as I say, make no finding of fact that what Mr. Perry had emphatically said in his witness statement was untrue. He rather said that he could not honestly make a claim in the underlying proceedings. And I shall come to that point when I deal with a second ground of appeal. I'm grateful. My friend has identified the passage in which Lord Mance deals with the conventional approach, and it's at paragraph 2 of his judgment at page 1265.
Very distinguished Court of Appeal from Gibraltar that he was disagreeing with.
Yeah, indeed, milady, and of course, given that fact, a judgment from that tribunal is given very great weight, as I understand it, and is regarded as having great persuasive value.
The comment I was making was that the Court of Appeal of Gibraltar,
Yes.
from whom the Judicial Committee of the Privy Council was
Yes.
differing
Yes.
on a matter of quantification of damage, was a very distinguished court.
Yes, indeed. and indeed, the Privy Council was a very distinguished court.
Well, they always are. You take that
Yes,
for granted.
yes. May I then take the court to Hanif and Middleweeks, which is at tab 11, starting at page 1146. It's a particularly instructive decision, this, because the underlying claim, which was lost through negligence, raised issues of illegality, arson and dishonesty, fraud.
But there was no issue as to causation.
Well, the counterclaim had been made and it had been struck out.
Absolutely no issue.
Yes, yes.
Mr.
But-
Hanif was always going to make his insurance claim, wasn't he?
But he had in fact made it, because the insurers had sought a declaration, and he had counterclaimed for payment under the policy. But the reason why it remains relevant, milady, is that part of Raleys' defence of this claim concerns matters of policy. And it is said, for instance, that the courts shouldn't assist parties who are, in the underlying claim, making a dishonest or fraudulent claim or something of that sort. And although that is a policy factor which courts, when properly seized of the matter, can deal with, it is not something which rules out these claims altogether. The underlying claim, as is well known, concerned three issues. One was breach of condition precedent under the insurance contract, another was material non-disclosure, and the third was fraud, in that the fire had been intentionally started by the claimant, Mr. Hanif's business partner. And that is the claim that was struck out. The judge trying the professional negligence claim found that there was an 80% chance of success on the condition precedent. There was a 60% chance of success on the material non-disclosure, but only a 25% chance of success, so well below the balance of probabilities. And it was taken on appeal on the basis that in those circumstances he should have received nothing, and three particular arguments were put before the Court of Appeal, and those reflect very much the arguments which are put by Raleys in this case. The first was that the judge had found positively that there was arson, and he should not therefore have gone on to assess the prospects of Mr. Hanif's persuading a judge at the notional trial that there had been no arson. The second was that given the
Where do you find that?
milady, that is at paragraphs 7 and 53 of the judgment. Paragraph 7 is at page 1147. And 53 is at page 1152.
Thank you.
The second main point put before the Court of Appeal was that given that finding of arson, as they sought, the solicitor's negligence had not caused any loss. And that is to be found at paragraphs 54 and 55 of the report. in the judgment of Lord Justice Roach. And then thirdly, the professional negligence claim should fail on grounds of public policy in that the judge had found on the balance of probabilities that there was arson, and that is to be found at paragraphs 30 and 53 of the judgment.
30 and 50.
And 53.
The 50s paragraphs are in the judgment of Lord Justice Roach, and the earlier ones in the judgment of Lord Justice.
That tends to be. Lord Justice Mance gave the leading and longer judgment, and Lord Justice Roach a rather shorter one at the end, but covering the same points. Now, all of those arguments failed, and if I may take the court to the judgment of Lord Justice Mance at paragraph 18 on page 1149. He said that the judge, that was not his role. The only role which he assumed was to assess whether there were any, and if so, what significant prospects under the original counterclaim.
So the criticism that the judge had positively found that there was arson was rejected on the basis that the judge had not positively found arson.
And the reason he had not positively found it was that he was not carrying out a trial within a trial. He was assessing the prospects. And at paragraph 29, about halfway down that paragraph, if he had assumed that role, I consider that he would, in the light of accepted principle and authority, have been wrong in this case to do so.
Well, that was a case in which it was very unlikely the judge was going to do that because the evidence wasn't available, was it?
Well,
It's a bit like Kitchen.
in this case as well, there had been a long delay between the negligent advice leading to the settlement and the actual trial. The negligent advice leading to the settlement was in December 1999, and the trial was eventually heard some 15 years later, in late March.
It's not quite the same category of case, is it, where you've got a fire and all the evidence that you might need to establish arson wasn't available before the trial judge, whereas this is a rather different state of affairs. All I'm getting at is that the trial judge had done the right thing and merely assessed the prospects, hadn't found as a fact whether or not there was arson.
But he had done the right thing with respect, my lady, because that is what, from the time of Kitchen, has been recognised as the appropriate way in adjudicating upon these professional negligence claims. They are loss of chance claims. And that is what the judge dealing with the professional negligence action is required to do. In fact, at paragraph 17 of his judgment, Lord Justice Mance remarks upon some of the odd consequences which would flow if the judge were making findings of fact as they might have been made in the underlying proceedings had they gone ahead.
Those appear to be odd consequences viewed through the prism of trying to assess the value of a shows in action considering of a lost claim, a claim that can't now be brought, such that a 49% chance would give you 0 and a 51% chance would give you 100. Do any similar oddities surround the forensic task of assessing whether a claim could honestly have been brought, if that depends upon matters, on the face of it, leaving aside medical evidence, entirely within the knowledge of the person who says he would have brought them?
My Lord, the question is, what is the proper issue? How is it defined, the causation issue? And that is, would he have acted differently? If it is to be said, when he says, I would have acted differently and brought an action, that he is lying and that it's a dishonest claim, then there are various steps, and I do plan to come to this, which the defendant in that situation can take, can apply, for instance, to have the claim struck out as an abuse of the process, both under the inherent jurisdiction of the court and under the CPR, can raise a defense of fraud, fair and square, and assume the onus of proving that case. Or thirdly, as has been done by Raleys in another case, without success as it happens, raise the defense of ex turpi causa. And then the court will have to consider the public policy factors if it is satisfied that there has been dishonesty, which need to be considered when those sorts of defenses are run.
You've shown us how firmly your client said, I would have brought the claim. But was that firm assertion not based upon his evidence? I could do these things unassisted before, but I couldn't do them afterwards. And if the judge, having looked into this, knocks out that foundation, doesn't your client's assertion fall?
Well, my Lord, it wasn't just the client who said those things. He was corroborated by his wife and his two sons, and he was importantly corroborated by the medical evidence of two medical experts. The original expert, Professor Kester, whose report had been commissioned by Raleys, and whose report classified his VWF as being V3 and 3SN, so of a serious nature, which was presumed to give rise to a need for it, and it was commended to the client by Raleys that he should rely upon this report and make his claim. So one is dealing with the evidential burden which passes on to the negligent solicitors in those circumstances. And thereafter, the jointly appointed expert, Mr. Tennant, who, and I plan to take the court to his evidence just to show how strongly corroborative it is in this particular case.
Thank you.
The other point, the second point, which was dismissed by Lord Justice Mance, was that the claimant could not prove that he had suffered any loss in these circumstances, and that is dealt with in paragraph 21.
Well, of course, if the trial judge had found, as he should not have found, that there was arson, well, then it would follow that the claimant wouldn't be able to prove any loss. But it doesn't help us very much.
Yeah, well, milady, I suggest that it does, because what it shows is that what the court is supposed to do is to assess prospects of the underlying claim.
Yes.
Not to make firm findings. I
don't think that's in dispute. I think that that's not a problem. The problem is the earlier question.
And the point is that this judge didn't say, I find that there was only a 20% chance of his succeeding on causation. He didn't quantify it. He just dismissed his evidence because he posed the question in a certain way and said he was not satisfied on the balance of probabilities that he had discharged that onus. But certainly there can be no doubt that a finding that the prospects of success in the arson and the fraud claim were only 20% because they were reduced by the Court of Appeal is so far below 50% that it must follow that if there had been a trial, it would have been entirely unsuccessful. And that is why we say it is relevant, and it applies as much to the causation question as to the quantification issue. And then he also dismissed the public policy reason for overturning the trial judge's judgment, and that is at paragraph 30 of his judgment. Now, Raleys, as I've indicated, seek to distinguish Hanif and Middle Weeks on the basis that it concerned a case where the counterclaim was struck out because a fair trial was no longer possible. I've explained why the facts in this case are similar because of delay. Facts are more difficult to establish and so on. And our submission is that the sort of prejudice that the court was concerned with in Hanif and Middle Weeks would arise in this case as well. I draw to the court's attention that it is not only in cases of strikeout for delay, but in other cases as well. Phillips and Whaley was a failure to issue within the limitation period. Dixon and Clement Jones at tab 7 of the authorities bundle concerned the failure to serve the statement of claim timelessly. And most recently, in the Court of Appeal, Edwards and Hugh James Ford Symie at tab 8, like this case, concerned the failure properly to advise a claimant on the services claim. And so the principles apply even where there are not, in the particular circumstances of the case, grounds to find that there is prejudice because of delay. Apart from the Court of Appeal in Hanif and Middle Weeks deciding that a claimant could succeed even where his claim had only a 20% prospect of success, we have other low awards in other cases, the most striking of which is in the case of Sharp and Addison, a Court of Appeal decision in 2003, which is in the supplemental bundle, where the Court of Appeal reversed the trial judge's refusal or dismissal of the claim and held that 10% of the value was recoverable. And the relevant passages there are at pages 17 and 18. Paragraph 50 of Lord Justice Ricks's judgment, he explains how there was only a 10% prospect of success.
And we don't have this electronically.
No, my lady, I'm afraid.
Lady, I think you do.
It's in,
Has it been attached to the main bundle?
I think it's attached to the authorities bundle.
Okay.
I'm grateful.
Could you give me the name of the case again?
It's Sharp and Addison.
Ah, yes.
Oh, I see. Yes,
Yes, it's not
yes.
that's
It's
just how it should be.
yeah.
Not a separate document.
No, that's excellent. Yes, thank you.
Thank you. What page did you want to refer us to?
Well,
Paragraph?
I drew attention to the actual assessment of the Court of Appeal that he should recover 10% compensation of the overall value of the claim because the prospects were that low. At very best for him, if he had been able to establish primary liability, he would have had his compensation discounted by 75% for contributory negligence. Yes, it's paragraph 50, milady. And there was only at best a 40% prospect of establishing liability, primary liability.
It's the other reference. 35 is the other reference.
Yes.
But the negligence there was, as I understand it, the late notification of issue to Emma's insurers.
Yes, indeed. Yes, because the driver of the taxi cab who had knocked this man down could not be traced.
Yeah.
And they were only a day out when it came to the notification.
There was no decision-making for the claimant to have to do about whether or not to bring a claim. He wanted to bring a claim.
Well, his litigation friend wanted to bring a claim.
Yes,
He was so injured that he no longer had capacity.
The litigation friend. There was no decision-making of the type there is in the present case.
No, my lord. So far as the judge decided, he did decide that this claimant could not discharge the onus of proving that he bring an honest claim. We say that that was not the point to be addressed, and moreover, as emerges from Raleys' printed case, a conscious decision apparently was made not to plead dishonesty or fraud. And we see that in paragraph 9. At page 61.
At the moment, I don't understand this business about, well, they didn't plead dishonesty. Their whole case was, you were going to be honest. And if you lack the foundation for making a services claim, it wasn't going to be made. So how does dishonesty and fraud come into it? And why are we inquiring why it wasn't alleged?
Well, my lord, it comes into it in this way. On the one hand, they say you would not have made a claim because you knew that you didn't qualify. You were then honest. Now, dishonestly, because it must follow if he's making a claim now that he wouldn't have made then because he realized he didn't qualify. Now, dishonestly, you are making a claim against us, the solicitors, who have admitted that we were negligent.
Your current evidence is exaggerated or perhaps dishonest.
Well, it's dishonest.
Dishonest.
Yes.
Okay.
Because exaggeration would go...
Yes, okay.
Yes.
This exaggeration wouldn't answer the second limb.
No. And that is simply a paradox to say that he was honest then but not honest now. And that's something which Lord Justice Kay remarked upon in the Barnaby case as the problem in the way of that theory of a case by solicitors, that they are putting forward this person who's both honest and dishonest, who happens to be dishonest when it comes to the claim against them. But they consciously have decided not to raise it.
Even so, is that a point that has to be pleaded? I mean, what you're saying, as I understand, or what you say they're saying, is that this is a dishonest claim against the solicitors because the substratum doesn't exist for the pursuit of the claim. But it's enough generally just to deny the substratum, isn't it?
That is the claim put by the solicitors, and it's reflected in the judgment of His Honour Judge Safman when he says Mr. Quiney said it was a matter, I think it's paragraph 118 of his judgment. Or is it 119?
Page 176.
176. And then in his actual findings, if your lordship would bear with me. Ultimately, in paragraph 133 at page 178, the claimant has not established that he honestly met the factual matrix, is the finding of the judge, by reason of his VWF, either in respect of what tasks he used to do and those which he could no longer do without assistance at the time of settlement of his claim.
Talks about honest meeting. Presumably, he had an honest belief that he met.
Yes.
Yes.
Now, my lords, if that is what the judge finds when he is being urged by defense counsel to treat this as a matter of credibility and a matter where the claimant, so the judge holds, as a result of those submissions, must prove that he can bring an honest claim, they are raising issues of fraud or extirpi causa. And those are issues which it would be fair enough for them to plead if they had the factual grounds on which to do that. And as I've said, the various courses open to them are either to apply to have the matter struck out because it is an abuse of the process, in line with this court's decision in Summers and Fairclough Holmes. It's not in the bundle, but it was the full reference is 2012 UKSC 26 and reported in the 2012 first volume of Weekly Law Reports at 2004. Or to plead a fraud, or as I say, extirpi causa, in which event the defendant will bear the onus of making out that defense. And if illegality or extirpi causa is raised, then the court has to determine whether in allowing a claim, a dishonest claim, to proceed, that would produce some inconsistency or disharmony in the law, for instance. And the various policies in issue will then have to be weighed up and a determination made as to which of those shall succeed. In our submission, it is not the case that, especially if it hasn't been pleaded, that there is a public interest in denying a claimant compensation where the solicitors have been negligent and he's lost the prospect of bringing a claim. Because that is not likely to reduce the scourge of fraudulent claims that happen in low-impact collisions, for instance. More likely to reduce that problem is that solicitors are required to take proper instructions, and if they are suspicious about a claim, to warn their client of the possible consequences if his claim is found not to be an honest one. There is, in our submission, as Lady Justice Gloucester recognized, a genuine public interest that solicitors should serve their clients non-negligently and that they should give them proper advice, and if they fail, that they should be responsible for the compensation, which will be a fair one, because the court on this loss of chance claim assesses it only to the extent that the client may have hoped to have succeeded in the underlying claim. It was, in our submission, particularly inappropriate in this case to have allowed the sort of factual inquiry that Judge Safman did, particularly bearing in mind the nature of the VWF compensation scheme, which was supposed to be informal, inexpensive, straightforward, and broad brush. And that is why the presumptions were recognized in the scheme, that certain gradings would give rise to the certain needs. That is why the evidence was taken by short questionnaires being completed both by the claimant and by those people who had provided assistance or the entire service that he could no longer carry out.
Are you saying that a dishonest claim would have been likely not to have been discovered?
Yes, indeed, my lord, because of that informality. There was no disclosure required. There was the MAP 1 report, and Professor Kester's report was treated as a MAP 1 report, with its gradings accepted, and Mr. Perry was compensated with general damages reflective of that severity of grading. So there was no disclosure, there would have been no live evidence, no cross-examination. The closest there was to live evidence was that there would be a short telephone call of about 15 minutes to the helpers. And as the agreed facts indicate, even if the helper was out by some margin in the dates of the onset of the symptoms and the assistance that was given, that would not lead to the failure of the case. I can take your lordships to that particular part. And that is at page 46 of Core Bundle 1, at paragraph 9.6.
So page?
46, my lord.
46, thank you.
My lord, it may be worth mentioning in this context the point that was made in the original case of Kitchen and the Royal Air Force Association, where Lord Evershed said that if it were accepted by the client that he or she had no claim, but simply that it had some nuisance value, that is not something which the court would compensate. And the reason in principle for that is, of course, that it is one of those rare cases where there's no valuable claim, no valuable chosen action. And it would fail in those circumstances. But this is not such a case. It has never been Mr. Perry's case, and it was never put to him that it was a case that he was just trying it on because it was of nuisance value. There is an alternative way that the claimant puts this case, and that is to say, well, it doesn't come within the duty of care which is owed. The respondent puts the case. The appellant, I'm grateful. And it is on the basis that the only thing that the solicitor needed ask his client was, do you, Mr. Perry, need assistance with your gardening and DIY because of the problems with your hands? They say if he had answered yes, well, then they could proceed with a claim. If he answered no, that would bring the end to the matter, and that was the satisfaction of their duty so far as advising him is concerned. Our submission, my lords, my lady, is that it is a rather wider duty than that, and he should have had explained to him in the sort of terms that have subsequently been explained to him and are set out in his witness statement to which I took you, what the nature of the services claim was, and what he needed to show in order to qualify for an award. They would also be obliged, the solicitors, to obtain the information from him to see whether he satisfied it, and as I've said, if they were concerned that he may be advancing or thinking of advancing a false claim, to warn him of the dangers of that. Ultimately, if they felt that he was determined to do so and they were not prepared to act for him, they were entitled to withdraw from representing him. But that is a very much more extensive duty that they owe to their client than the simple one of saying, do you need assistance with your gardening that you didn't need before because of problems with your hands? Now, the alternative analysis, which is at pages 72 and 73 of their written case, we say is based on this unrealistic formulation of a circumscribed duty of care. And as with that, it is based on the non sequitur that it is wrong to advise a client in respect of a claim when there is a possibility that it may be a dishonest claim, instead of advising him on the claim and then also advising him of the consequences of pursuing a false claim. The mere risk...
As you say in your case, this alternative analysis was never advanced in either of the lower courts, and I didn't think that it was advanced orally by Mr. Pools today.
No, my lord, it is in their written case.
It is?
Yes. But
There is an element of pot and kettle, of course, isn't there?
Oh, yes, my lady. There always is, I imagine. And it certainly is also, in our submission, contrary to the established principles exemplified in Hanif and Middleweek. So, in summary on ground one, we do say that the right question was asked, but it was elaborated upon, and the wrong question was answered by Judge Safman. And if he had stuck to the right question and actually answered it, which he did not do, then it must have followed that this claimant would have succeeded on causation, and the only issue remaining for Judge Safman, and one that he, in the event, carried out, was to assess what the prospects were and to quantify the loss of a chance, or the value of the chance that had been lost as a result of the negligence. And he said it was 80% of the claim. If I may, I will then turn to ground two, which arises only if this court is against the respondent on ground one. It was accepted by Lady Justice Gloucester and the Court of Appeal, that there are limited circumstances in which it is appropriate for an appellate court to interfere with a judge's findings of fact. And she set out in some detail in her judgment the leading cases from this court and from the Court of Appeal of McGrady and Henderson and Foxworth, and also Grizzly Business and Stenner Drilling in the Court of Appeal. And they are in the bundle. Your Lordships, my lady, will be well familiar with them. She also cited Fage UK and Chobani UK Limited, a decision of the Court of Appeal in 2014, which isn't in the bundle. But she directed herself by reference to those cases, and it is at pages 130 to 134 of her judgment, at paragraphs 24 and to 26. And in our submission, she rightly concluded that Judge Safman had demonstrably failed to consider or had misunderstood relevant evidence. And the first example, that is the first example of the sort of error which warrants interference by an appellate court, given in paragraph 67 of the case of Henderson and Foxworth. And she also held that his decision could not reasonably be explained or justified, and that would be in the sense that it was a decision to which no reasonable judge could have come. Now, our case on the second ground is set out at pages 98 to 174 of our written case.
98 to?
98 to 107.
107?
Yes.
Paragraphs.
Yes. Yeah. And paragraphs 32 to 43.
Thank you.
I know that the court has read the written cases, and I don't propose to go through all of the arguments there. If I may, I wish to concentrate on two main topics. The first concerns the judge's findings concerning the gardening and the evidence relating to the gardening. It is important in our submission to recognize that it was never disputed that before he became, or before he developed vibration white finger, Mr. Perry had carried out the gardening. Now, the judge, in making findings adverse to Mr. Perry and rejecting his evidence, fundamentally misunderstood what he was actually saying about the gardening. And we see that at page 165, paragraph 61 of his judgment. It is the claimant's evidence that his VWF precludes him from gardening. And it goes on to set out the history as the judge understands it. He moved to the property, that's the property in which they still live, in 1999, well after, on his evidence, he had become unable to garden himself. And then at page 176, paragraph 119, it is required that he should say, "I cannot carry out these services."
Yes, okay, but you'll have noticed in 118 the word unassisted, and you'll have noticed in 121 the word unaided. There are at least 4 references in this judgment to the test being whether he can do things without assistance. And I suppose one has to read the passages upon which you understandably rely in that light.
Yes, my lord, but there is a difference between the instances where the judge is referring to the test under VWF and the passages where he is considering the evidence which he says is the claimant's case, not partial disability, but completely in a complete incapacity to carry out. And it was on that basis that that understanding that he made adverse findings against this particular claimant. And we see it again at paragraph 176, or page 176, paragraph 124. Further, it is of course the claimant's case that he cannot garden. It is an element of the services claim. And then he goes on to say why it's difficult then to understand why there are these 2 GP records where there are references to his having been involved in gardening.
A lot of gardening.
Yes, in 125. He is now incapable of doing so, that's the gardening, and he finds it difficult to credit that he would then move to a property with a much bigger garden. So the judge does attach significance to what he understood this claimant's evidence to be. His evidence was not that he had a complete incapacity, and the court will see that in his witness statement at Core Bundle 2, page 534, paragraph 49, and also at page 535, paragraph 53. Is paragraph 49, where he says that he does a bit of tidying up which needs to be done in the garden. He suffers if he tries to use the manual lawn mower, but he's able to sit down on the sit-down mower. And then in paragraph 53, he says that his sons, Dean and Scott, do the majority of the jobs. In cross-examination, he confirmed that Dean and Scott now did the majority of the jobs. And I'm conscious of the time, so if I could simply give the page reference. That is at Core Bundle 1 at pages 228H to 229D. He also confirmed in cross-examination that he was able to collect the leaves, do the sweeping up and minor jobs, and added, I'm not completely disabled. And that is at page 242G to 243B. This misunderstanding by Judge Safman in our submission was particularly serious because of the 6 tasks covered by the services scheme, the cross-examination mostly focused on the gardening. And it was his rejection of the idea that the claimant could honestly say that he was incapable of gardening that influenced his decision on all of the tasks, not just the gardening. Little was said about the other tasks in cross-examination. Again, if I may deal fairly briskly with the corroborative evidence of Mrs. Perry and the sons, Mrs. Perry sets out very fully in her first witness statement the extent to which she had taken over the gardening and other tasks which her husband had previously done. And that is at Core Bundle 2, tab 20, pages 597 to 600. It was also a matter of assisting him rather than performing all of the tasks as a result of complete incapacity on his part. It's perhaps instructive to look at the very brief cross-examination of Mrs. Perry, and that is at Core Bundle 1, tab F, at page 268 and 275.
Sorry, page.
268 to 275.
Thank you.
It is put to her at page 270, at the letters A to B. You did not have to do any jobs for him, did you? And she says, I did. And it is left there. And then he asks her about the problems with his stomach at 270C. And he had other serious problems with his back as well, and that's at 270E. The line of questioning at pages 272B to C was that the problems with carrying out these manual tasks was because of his back. And she responded that that was not 100% of the problem, no. And then he winds up at page 275, the letters A to B, referring again to the back. And it's 275A to B, and says, the truth of the matter is that you are here to support your husband's claim, are you not? And she quite rightly says, I am, yes. There's no vice in that, I'm sure. And then he adds, without any foundation having been laid in the earlier cross-examination, simply you will say, whatever is required to support that claim, will you not? And she responded with commendable courtesy, I will answer your question to the best of my ability.
This is the oddity. I mean, she's cross-examined on the basis that he has a disability in respect of his tasks. It's put down to the back. She doesn't accept that. And the judge eventually finds that the back isn't the dominant thing, it's merely a matter of comorbidity.
And therefore, it appears to have been acknowledged that assistance was provided. And the judge has simply decided that it wasn't a case of the back eclipsing the hands and giving rise to that need. And yet that isn't addressed, the logic of it isn't addressed in his judgment. If I may briefly give the page references to the same style of cross-examination when it came to the youngest son, the second witness, John Scott Perry, who was known as Scott. His statements are at Core Bundle 2, and they are at tab 23 at pages 623 to 628, and also tab 24 at pages 629 to 631. And he confirmed that as long as he could remember, he had helped his father around the house. He said that his father used to enjoy gardening and did all the gardening before he developed VWF, and that he and Dean, his elder brother, and his mother now, he indeed do the heavy work, and his mother now does the light work, and it's fully set out there. None of this detailed evidence was challenged in cross-examination with him. And again, if I can take my lady and my lords to the relevant section of the transcript, his cross-examination starts on page 276. And it runs for only 3 short pages, really, 4 pages. And at page 277, D to E, he's asked about whether it's the back or the hands, and he says it may have been the back, but that he was also having problems with his hands. And then at G to H as well. It's not contested that he provided the assistance. And then at page 278H, he's asked about the reason for the digging, and it's suggested that it's down to his back, not his hands. And again, without any foundation having been laid, it is again saying that he's willing to say anything to support his father. Page 279B. But you are here to support his claim, are you not? Yes, I am. And then it says, your assertion just now regarding how his attacks may come on by using tools is an example of how you do anything to support him. Now, in our submission, the judge did need to deal with the evidence and the lack of challenge to important parts of that corroborative evidence from members of the family. And in failing to do so, particularly when that failure was also connected with his misunderstanding of what the claimant's case was, namely, I cannot garden at all, as opposed to I need assistance with gardening, I do some light tasks. That was a fundamental mistake and error which influenced his assessment of the claim overall. And there were 5 other services which were covered by the claim. May I then turn to the medical issue? We say that it was a serious misdirection, judged to have found that there was dishonesty in respect of the way in which he, the judge, mistakenly thought that Mr. Perry had reported his back problems to Mr. Tennant, the jointly instructed vascular surgeon. It's important that the court should look carefully at Mr. Tennant's, both Professor Kester's and Mr. Tennant's reports. But as a preamble to that, I draw particular attention to what is in Core Bundle 2 at page 505, behind tab 10, in the final narrative part of this report, Comments and Opinion, where Mr. Tennant has found a grading at 1V and 3SN bilaterally, and his last sentence is, would be expected to produce significant disability in all the assessed domains.
So which page is that?
505, my lord.
505, thank you.
And then at 506, in tabular form, going over to 507, he deals with each of the claims which was presumed to require at least assistance, and with the exception of car maintenance, where he has assessed the VWF element to be moderate, in all of the others, he has found that there was complete disability. Now, at paragraph 122 of his judgment, the judge drew a very adverse, or made a very adverse finding against Mr. Perry, and that's at page 176 of the transcript of his judgment.
122. Did you say paragraph 122?
Yes, my lord, and it's page 176. It was difficult to understand how the claimant could have honestly suggested to Mr. Tennant that his back did not generally bother him, bearing in mind the contents of his applications for benefits. There were various benefits in which he claimed for back problems. I appreciate that Mr. Tennant saw him in 2013 and the benefits applications referring to the back problems or otherwise seemed to peter out from 2006. But the fact is that he had a back problem when he saw Mr. Tennant. He mentioned that this may prevent him from doing some of the service tasks during an attack, suggesting that his back problems were not under the control that he suggested. Now, back to Core Bundle 2, at page 502 in Mr. Tennant's original report. This is what Mr. Perry is recorded as having told Mr. Tennant under paragraph 2, second line in. He said that his only medical history was of a painful back since about 1994, which does not generally bother him. Now,
I'm awfully sorry, I haven't found that yet.
I beg your pardon?
We're on 502.
502.
Down at the bottom.
Last paragraph.
Oh, yes, yeah. Yes, I got it, thank you.
Now, that it transpired was a misunderstanding by Mr. Tennant. He had reported that, but the judge attributes that to something that Mr. Perry was actually saying, and Mr. Tennant corrects the misapprehension that he had and reported, and we find that behind tab 14 on page 515. And it's the penultimate paragraph on that page. What we see is that Mr. Tennant had listened to the voice recording of the interview and the examination, and he confirmed that what Mr. Perry stated, that he had a back problem for 20 years, but that it did not bother him all of the time. He thought that it would prevent him washing his car or digging the garden during an attack. And the mistake...
Attack of what?
During an attack of back pain. He didn't have it all the time, but it would prevent him if he was having an attack.
I didn't understand the attack that Mr. Tennant speaks of in the next sentence. That was back pain that distracted him temporarily during the examination. Yes.
I'm not sure that it was...
Broke out in a sweat and felt unwell.
Wonder.
Yes.
But we just don't know. Yes.
It had been well controlled since 1994, and that he had learned to cope with it.
Yeah.
But the judge had misinterpreted this evidence, which was the result of a mistake by Mr. Tennant, as being an instance of his being untruthful about the way in which his back affected him. First by originally saying it didn't generally bother him, and then rather backtracking by saying that well, it was still a problem when he had an attack. And it's clear that from the outset, that had been his evidence, and Mr. Tennant clarified that, and there was no longer any doubt about it. But it was another important respect in which the judge wrongly was prepared, on the basis of these inconsistencies and dishonesties, as he saw them, to make a finding that the judge, that Mr. Perry could not honestly have brought this claim because he did not satisfy the factual matrix. I'm conscious that my time is practically up, milady. We have set out, not in full detail, but in our written case, the arguments we advance under ground 2, with, I hope, all the necessary page reference. And we do ask that the court considers those passages in the evidence carefully, though time has prevented us from actually taking through them here this afternoon.
Well, you do have another 10 minutes.
Oh, I thought I had to stop at 22.
I don't think so.
No.
You have to stop at 10 to.
Um,
However, if you want to stop, we
No,
will
but,
discourage you.
lady, the point is...
It's not because we don't like listening to you, but we never encourage counsel to go on longer than necessary.
No, I am conscious that they have been set out in the written case, and it was these two in particular that I felt warranted some further exploration. Having underestimated the time I had, I assumed that I couldn't take you through the witness statements of the family members and in greater detail through the transcripts of their evidence, apart from those passages which I highlighted. But again, I would ask the court carefully to consider what is emphatically said in those witness statements and what in cross-examination was not challenged so far as the detail was concerned. And when it was challenged, how the emphasis tended to be on the basis that it was down to the back and not to the hands.
The critical point for you is that the existence of assistance by the family because of a disability on the part of Mr. Perry was not challenged in the corroborative cross-examinations. And it was put down to the back. And later on, he said, if I'd had to consider it, I would have said the back was merely a comorbidity.
Yes, well, that was the medical evidence. And the judge actually rejected the back as the eclipsing
Cause.
Yes, because that was another of the arguments that was rung.
Which was the hypothesis of the cross-examination as to
Yes.
why the assistance was given.
And it was foreshadowed in the written opening submissions before the trial that in reality would have been the cause of any problems he was having. So my lady, my lords, unless I can assist further, those are the submissions on behalf of the respondent.
Thank you very much indeed, Mr. Watt-Pringle. Mr. Greenborn, is there anything more you'd like to say?
No, lady.
Thank you. Mr. Poole.
Well, lady, I will leave myself to the 10 minutes maximum in any event. And perhaps I can say just a very few words about the criticisms made by a learned friend about the judgment of Judge Safman in respect to the medical evidence. He took you to paragraphs 122 and 123 at page 176 of Judge Safman's judgment in Call 1. And he then took you, I apologise for making two references at the same time, to page 515.
I'm sorry, can you just give me that first reference again?
Sorry, the first reference was page 176.
Paragraphs
122, he took you to, but you have to read on to paragraph 123, because if you then look back at the document from Mr. Tennant at page 515, to which my learned friend took you, which recites, "I've listened to the voice recording," you then have to turn the page. There is no doubt that Mr. Perry has suffered from intermittent back pain for the last 20 years or so. However, the severity of that pain and the limitations imposed by it appear to be veiled in conflicting reports and medical records. That's exactly the passage the judge quotes in paragraph 123, and it is clear the judge had a very clear picture of the conflicting accounts which had been provided both to Mr. Tennant and others.
Just give me the page reference for that again.
516.
516.
516.
Thank you. Yes, I've
Second
got it.
page of the letter.
Yeah.
So, my lady, with respect, in respect of that allegation, and particularly if looking back at the accounts given to Mr. Tennant of the claimant's gardening abilities and disabilities at page 504, I was giving Mr. Tennant an account as to what he could or couldn't do as to gardening. He last mowed his lawn in the middle of 1990s, as using a lawnmower brings on an attack of numbness and blanching in his hands. Cannot use a powered hedge trimmer either for the same reason. Sun trims the hedges. What the learned judge at trial was confronted with, in a very familiar way to any judicial process, was a witness whose evidence was intrinsically, as he found it, unreliable for a variety of reasons. He took into account the man's disability, as found by the doctors, as you've seen. He took into account the evidence provided by the family, but at the end of the day, he was not satisfied. And that was a conclusion which he was fully entitled to reach for all of the reasons he set out. My friend has very fairly said, we have both set out the references to the evidence. If you are satisfied that there is a basis upon which an appellate court can interfere with this judgment, no doubt you will consider those matters in greater detail. But our primary submission is there was no proper basis for such a challenge in the face of the judgment as it was set out, which was judgmental upon the totality of the evidence presented by the claimant in support of his case on causation. So far as the case on causation is concerned, our submission remains the same. My learned friend makes no reference to Allied Maples. The court is not invited to depart from Allied Maples. The question of causation, would a claim have been brought, is quintessentially an issue under Flag 2, Category 2 of Allied Maples, and that involved the judge hearing all of the relevant evidence, and it included evidence as to the factual matrix which would have justified or not justified a claim. My learned friend seeks to invite you implicitly to follow the heresy which was adopted implicitly by the Court of Appeal by fudging the issue of quantification of damage and causation in bringing a claim. There is no basis for doing so, and to do so would be a manifest departure from the basic tenet of tort law as set out by Lord Justice Stuart Smith in Allied Maples. So far as the criticisms of Judge Safman are concerned, at the end of the day, he set out the issue which he had to determine at the outcome of his assessment. And my learned friend doesn't criticize paragraph 118. If one then turns to paragraphs 120 and 121
I thought he did criticise 118.
It was 88 he didn't criticise.
So 80, it sets it at 88. I do beg your pardon. At 118, in our submission, it does not significantly depart from what has gone before. The judge clearly has the right issue in mind, and at 119 rightly identifies that it is a question of credibility. He then sets out the test. Am I satisfied the claimant originally undertook the services but could no longer do without assistance? 120 deals with his assessment of the evidence. Bound to say the claimant's evidence was far from convincing. I'm not satisfied by it. I don't ignore Reby and the fact, although there's no gloss on the standard of proof, the context of inherent possibilities, dishonesty is more improbable than honesty. However, the fact of the matter is that much of the claimant's evidence was at variance with much of the written and extraneous evidence, and his explanations for this were not impressive. Neither do I ignore that he clearly suffered from VWF. I have to be satisfied that in actual fact he could not perform unaided the tasks which he did carry out unaided before the onset of VWF. That is the right question being addressed in the right way. And then dealing with the family, he deals with paragraph 133 on page 178. I'm not satisfied that the evidence of Mrs. Perry or Scott Perry is sufficiently cogent to dissuade me from my conclusion that the claimant hasn't established that he honestly met the factual matrix by reason of his VWF, either in respect of what tasks he used to do and those with which he could not do without assistance at the time of settlement of his original claim. And he goes further than that. Those were the correct questions addressed in a logical fashion and determined in a way which any trial judge was permitted to do in the circumstances of the case. My lords, my lady, unless there's any other particular matter on which I can assist you, I don't propose to add any more.
No, thank you very much indeed, Mr. Pauls. Thank you. Well, we're most grateful to everyone, and particularly for the answers to some intriguing questions about the history of this litigation, for which it's very useful to have the people who were actually present at the time. Thank you very much indeed, and for your written as well as your oral arguments. We will now go away and work out what we think the answer is and let you know in the usual fashion. The court is now adjourned.